and provided to counsel yesterday. First of all, I was given a probation records sometime during the course of the day yesterday. I reviewed those. I'm going to order them provided both to the state and the defense.
That's been done, Your Honor.
Thank you very much, Ms. Shakita. I also reviewed education records of Mr. Smith. Those records, I indicated which ones would be released. Generally, my ruling, as I stated earlier, was all records prior to October 31st, 2006 would be released, and there were a few records that were several days or several weeks after October 31st, 2006, but had the signature or referenced findings made by the witness, Dr. Evans, I believe is her name. So I also provided, unsealed those records and provided those to the state. All right, very good. So other matters?
I've handed up two motions. The first one I would ask Your Honor to consider is preventing a live broadcast. The first and only witness that the state intends to call this morning is Hannah Jones. And given that she is 10 years of age, there is a lot of publicity, and I put this in my motion, in their hometown of Cleveland, Tennessee, and out of a respect for her privacy, I cite 15-166, which, as Your Honor knows, deals mainly with sex offenses and talking about allowing the victims, essentially in those types of cases, to testify or to close the courtroom. I'm not asking you to close the courtroom. I'm just asking, Your Honor, out of the privacy of Hannah Jones, that there's not a live broadcast of her testimony. So I would submit that it's less restrictive or less expansive than actually closing the courtroom, and would ask Your Honor to consider that. I don't think the defense has an objection to that. That's correct.
All right. That request is consistent with Rule 15 of the General Rules of Practice before the Superior and District Court rules that coverage of minors is prohibited. And in this case, I would find that the interest of justice outweigh the interests in having this live broadcast for this witness. So I'm going to allow the motion and ask that both the audio images and the video images of this witness be, not broadcast during her testimony.
The other motion I have filed, Your Honor, is what I believe is keeping in line with the relevant case law. There was a lot of talk about Ronald Anthony and his culpability in terms of the guilt-innocence phase of this case, and I have filed a motion in limine to prevent the defense from referencing his plea or sentencing in this portion of the hearing. As I read the case law, it is not only irrelevant, it's improper, and it does not go to either the aspect of the defendant's character and is not a mitigating circumstances. So I would submit to the court that based on the case law that it is improper and irrelevant and should not be allowed in this phase. In addition, I think that taking it one step further, if the defense were allowed to talk about that, it would be unfair to the state because we wouldn't be in a position to say that that same offer was extended to the defendant. So I would ask Your Honor to prohibit the defense from making a reference to Ronald Anthony's plea or sentence in this stage.
All right, Mr. Brown.
I would point out that the sentence, Mr. Anthony's plea and sentence was submitted to the jury, was brought forth to the jury properly for the purposes of impeachment purposes, that we had that discussion before the court, before the jury about it and all. I think this is an argument largely going to the argument phase of this plea, and so it may be appropriate before we get to that phase. I don't think we're intending to try to get elicit that from any more witnesses. It's already before the jury. There is case law that suggests if it's before the jury, it's appropriate for the jury to consider that as a catch-all mitigating circumstance. I understand, and we will have formal objections probably to Ms. Shakita's point that it shouldn't be offered as a mitigating circumstance. I do understand that the case law is against us in that, but there is case law and I cite specifically State v. Roseboro, 351 NC 536 2000, that talks about when it's before the jury, and there's a couple other cases that talk about it before the jury can consider that as a catch-all mitigating circumstance. But I do think that it's probably premature to take that up right now, given that we're not about to enter the argument stage.
But if they're not planning on introducing evidence, then certainly we can argue about it at a different time.
That's what we'll do then. I'm going to allow the motion based on the representations of the defense that it is not to be brought up in the evidence portion of this proceeding unless you bring it to our attention in advance and we talk about it further.
Right now, it's not our attention. If I can think of one circumstance where it would be, but I would not do anything without bringing it to the court's attention outside the presence of the jury.
That would be fine, and then we will talk about it again prior to the arguments. Anything else for the state?
No, sir.
All right. Ms. Brown, any matters you wish to bring to our attention, or Ms. D?
The only well, a couple of things. Well, the first matter is, I know that we're going to start out with victim impact evidence, and I know with Hannah's testimony, and we certainly would prefer not to have to do any type of objecting beforehand, so I just wanted to talk beforehand. There are certain limitations under Tennessee v. Payne that with it. Primarily, it's the regulations about what can be said and not said during victim impact. They certainly can talk about how much the victim meant to her, the impact it's had on her life. Cannot talk about what a preferable sentence is and other things about that. And so we'd prefer, I don't know the best way of doing it, whether it's either through a voir dire or a cautionary instructions, but in order so we don't have to have a fight about it in the middle of her testimony.
All right. I'll just simply ask the state, do you intend to elicit testimony from this witness on her opinion about the crime, the defendant, or the appropriate sentence? All right.
But she can talk about the impact that this has had on her and her brother and the unique loss to their family about this.
Right.
And that's what I intend to talk to her about.
Right. I think the best way to proceed is simply to hear any objections as they come up. I think with careful guidance through the questions, then the testimony should stay within the bounds of what the law permits. But if there are objections, we'll certainly hear them as they come up.
And I would not be good more, but I think it's out of abundance of caution, object to the testimony pursuant to the 8th and 14th Amendments of the United States Constitution with it and all, and just make that record known, and that's all I wanted to hear tonight.
That objection's overruled.
And
All
Your
right.
Honor, and Your Honor, I'm afraid we will forget, and so I want to mention
Yes.
now, we have one witness who I anticipate, well, I know she'll be called tomorrow because she doesn't fly in until tomorrow, but she has health problems that she doesn't really want for us to be discussing, but they may necessitate her having to stand up very suddenly when she's on the witness stand and leave. And so I told her that that would not be a problem and that you would be very understanding about that, but we would make sure to tell the court well in advance, and we'll give some indication of who she is before she testifies.
That'll be fine. We can accommodate that.
Okay. And we also have a witness today who's mostly blind, so if it's all right with the court, I'll help her up there and help her figure out where the Bible is and that kind of stuff.
Yes, that'll be fine. You're welcome to assist her. And also, if the bailiffs, if you need any assistance from the bailiffs, of course, they can help as well. All right. It's my intention just simply to inform the jury that they will be, that we now move to the sentencing phase of this matter, that it will proceed essentially along the same lines as the prior proceeding, namely we'll hear brief opening statements from counsel, then we'll move to evidence, and then there'll be closing I'll inform them that there are, based on their verdict, there are 2 possible penalties in this case, and that the court is bound by the recommendation, the unanimous recommendation of the jury with respect to the penalty. Anybody object to that general summary? All right, very good. Let's bring jurors. And I am going to ask the clerk to impanel the jury for this second phase as well. Ladies and gentlemen, and welcome back to the 3 alternates. You should have your notebooks in front of you, including the alternates should have their notebooks there. Based upon the verdict of the jury that was rendered yesterday, namely a verdict of guilty of first-degree murder on both the theories of premeditation and deliberation and the felony murder rule, we now move to the second phase of this proceeding. This is the sentencing phase of this proceeding. As you were explained earlier during the orientation process, there are 2 possible penalties that can be imposed for the in connection with the verdict that you've returned, namely the death sentence or life without the possibility of parole. We will move through this proceeding much the same way that we did the original phase, namely you will hear brief opening statements from counsel, you will then hear evidence, you will then hear the arguments of counsel, and then you'll hear my instructions on the law that you are to apply to the second phase of these proceedings. The court is bound by the unanimous recommendation of the jury with respect to the penalty in this case. So we'll move forward. If the state wishes to make an opening statement at this time, we'll hear from the state. Ms. Shakita. Oh, one moment. I'm going to ask the clerk to impanel you for this proceeding as well, just like you were impaneled for the first phase. Madam Clerk.
Members of the jury, you have been sworn and are now impaneled to determine the punishment to be imposed in the case of the state of North Carolina versus Travion Smith. You will sit together, hear the evidence, and render your verdict accordingly.
Thank you. Mr. Keith.
Yesterday, you determined that Travion Smith was responsible for the murder of Melissa Huggins-Jones during the course of the burglary into her home and for her malicious, premeditated, and deliberate murder. Now, as jurors, you are going to be asked to make the most serious and solemn decision that can be asked of any juror in this nation. At jury selection several weeks ago, each of you told us that there were certain crimes that you felt like might be appropriate for the death penalty. And you made a promise to Mr. Waller and myself that if we proved to you beyond a reasonable doubt that the death penalty was appropriate in this case, that you could in fact do that in this case. We do not take lightly the request that's getting ready to be made of you. And at the end of the evidence that you're going to hear during this second phase, or this sentencing phase, we are going to stand before you again and ask you to commit to that promise. That is, that we have met our burden of the steps we outlined in jury selection, and that the law will require you to sentence Travion Smith to death. We outlined the process earlier in jury selection, where the state has the burden of proof to show you aggravating circumstances beyond a reasonable doubt. And you're going to hear information that this killing was during the course of a robbery, where items were taken for their value senselessly while Melissa lay dying in her bed, knowing that she was dying, knowing that her daughter was across the apartment. The law requires that you consider all of the evidence from the guilt and innocence phase that you sat through for a couple of weeks. And I'm not going to waste your time in going through each and every item that you should consider in determining the appropriate aggravating circumstances, because Mr. Waller did so eloquently yesterday and laid it out for you. So I ask that you consider all of the evidence that you've already heard when you're considering whether we've met our burden of those aggravating circumstances. You are to remember, and we will ask that you remember, the brutal killing and the autopsy photographs, which were difficult for some of you to see, in determining whether this crime was especially heinous, atrocious, or cruel. I would ask you, when you're thinking about that, to recall the defense attorney's own account of this tragic and senseless death. Those were their words. In determining whether or not it rises to the level of heinous, atrocious, and cruel. And at the end of the sentencing phase, Judge Ridgway is going to tell you what that means, legally speaking. And I submit to you, you will be convinced beyond a reasonable doubt that the killing of Melissa Huggins-Jones satisfies that aggravating circumstance. Again, I submit to you that we will have proven to you beyond a reasonable doubt the heinous and cruel nature of the killing, that it was during the course of the robbery, and taken small things for this senseless killing. At that point, as you recall, when we talked with you several weeks ago individually, you'll be asked to consider the mitigating circumstances in this case. I ask you again to remember the defense's words when they talked to you about what a mitigating circumstance was. They told you it's not a defense, it's not an excuse, and it's going to be your determination that matters, whether you find that they are in fact mitigating or have any value at all. You're to consider all of the information that's been put forth for you, and we submit that once you consider those mitigating circumstances, whatever they may be, in light of the aggravating circumstances, that the state has met its burden to show you that they are insufficient to outweigh those aggravators. That is, the aggravating circumstances will weigh heavier in your mind. Again, you'll consider the nature of the crime during the commission of a robbery for inconsequential items, an iPhone, a Victoria's Secret bracelet. We would argue to you, and we will at a later date, that any mitigators you may hear are insufficient when you think about those aggravating circumstances. And then that last question we talked about, the one that it all comes down to, if you have found that those aggravators outweigh the mitigators, whether they're sufficiently substantial to warrant the imposition of the death penalty. We submit to you that you will hear, and recalling the evidence that you've already paid close attention to, that the killing was so senseless, so unnecessary in light of everything that you've heard, and we will ask you to find that those aggravators are in fact sufficiently substantial to warrant the imposition of the death penalty. These are serious requests that we will make of you, warranting serious consideration of all of the evidence, considering what you found to be credible in the guilt-innocence phase. During this last phase of the trial, there was a lot of blame put on someone else, someone who's already accepted responsibility. And I would ask you not to consider that. Obviously, whatever the judge tells you to consider is what's important. But what you're here to determine is what should happen to that man, Travion Smith, for his role in that senseless and tragic killing of a young woman who had moved here to Raleigh to start a new life. You will hear and recall about the death, and this phase will be about Travion Smith and the information you should consider in light of your responsibility and his responsibility and consequences in Melissa's death. I anticipate during the course of the sentencing phase that you may hear about some shortcomings or some issues that have come up in the defendant's life, that the defense will ask you to find mitigating, to have mitigating value in trying to determine and fashion the appropriate punishment. But I ask you to remember that you have now determined and labeled him a murderer in this case and responsible for her death. And I will ask you again at the end, or Mr. Waller will, or perhaps both of us, to reconsider some of the things that you've already heard. And I will ask you to recall those terrible circumstances leading to her death. Again, that she was excited of moving here with her daughter, soon to be reunited with her son, surrounded by a family and life that was new to her. And I ask you to consider all of those things that you've already listened hard to. And I ask you to consider the mitigating circumstances that will be presented to you, and you can determine what, if any, value to give it. But in a few short minutes, you're going to hear about a person whose life was also changed as a result of finding her mother dead. A child who had just started a new school. A child that was living a living room's distance away, asleep with a fan on. A child who was a fan's noise away from being a casualty. Because if you'll recall the testimony that came out during the course of the guilt-innocence phase, they were glad she didn't wake up, or they would have had to kill her. A child who woke up to the aftermath of this senseless and atrocious death, Hannah Jones, who lost her mother on May 14th of 2013. She's going to get up in front of you and tell you about the impact that this has had on her life and of her older brother, and that the unique loss that they have suffered and this community has suffered. After hearing from her, recounting the evidence that Mr. Waller passionately explained to you yesterday about how you should make your decision, we are going to ask you to make that most important decision, not only probably in your life, but in the defendant's life. And we are going to ask you to hold us to that burden, and when we meet it, we are going to ask that you come back into this courtroom, as difficult as it may be, and recommend to Judge Ridgway that this defendant be sentenced to death. Thank you.
Thank you, Ms. Shakita. Ms. D.
Thank you, Mama.
Ladies and gentlemen, capital punishment must be limited to offenders who commit the narrow category of the most serious crimes and whose extreme culpability makes them most deserving of execution. That's not an argument by me. That's the law. And that law is the basis for the evidence that you're going to hear in the coming days. That law is the basis for how you'll make the decision when you consider all the evidence and deliberate about all the evidence that you've already heard in the past 2 weeks and that you'll hear in the next 2 days. There are entire categories of people who aren't eligible for the death penalty because they are categorically incapable of the extreme culpability that the law requires. We don't execute people in the United States of America who are 18 years or younger because they are impulsive and they don't fully appreciate the nature of their actions and the wrongfulness of their actions. And for similar reasons, we don't execute people who have what we used to call mental retardation, but we now call intellectual disability. Those people are categorically removed from consideration for the ultimate punishment. You already know a great deal about Travion Smith's, about this crime, and about his role in it and the nature of his role in it. And when we stand up here for closings, we will ask you to consider his relative culpability in comparison to the other people that were involved and all the evidence that you heard. But now, we're going to ask you to listen carefully to evidence about the other category of mitigation that we talked about during jury selection. Evidence that's not directly related to the events surrounding the crime, but that nonetheless lessen the degree of culpability that Travion Smith has and make a sentence of life in prison the correct and the just sentence for Travion Smith. You're going to hear from his mother and other family members about his mother abandoning him as she abandoned her other 3 children, and about how her family, Antoinette's family, by the time her 4th child was born, no longer had the resources to sort of be invested and be participated in helping to raise those children. You'll learn about what was going on in his home when he was a very young child. Those years when love and nurture and security are so essential for the development of a child. Human babies are incapable of raising themselves. They must be cared for by other people. And Travion Smith was not. He was bounced around. His mother essentially gave him to a neighbor who loved him very much, but who had her own challenges and was only able to be involved in his life for a fairly short period of time because she was herself murdered when Travion was, I think he was 4, but she was murdered, and from that point forward was not able to be an ongoing participant in his life. Because of those early experiences over which Travion had no control, and because those experiences impacted who he became as an adult and what he has the capacity for, you will hear about them as mitigating circumstances. You'll also hear about the mitigating circumstances in Travion's life after he went to live with his father. The only constant in Travion's life, a man who didn't really want him and who was radically ill-equipped because of his own mental health issues and other limitations to parent Travion. By the time Travion came to live with his father, Travion had suffered emotional damage and required a lot of care. He required stability and he required structure. And from his father, he got no stability and no structure, and rather got a drumbeat of abuse from his dad through the years that he was with him. Finally, you'll hear from teachers and other professionals who worked with Travion in school and in other programs he attended. They will tell you how they remember him as a young person, how he reacted to positive reinforcement and how he reacted to structure. And they will tell you their memories of the dynamic between him and his father. None of these circumstances are excuses for this crime. The murder of Melissa Huggins-Jones was undoubtedly a first-degree murder. But after you hear the evidence of mitigating circumstances in this case, we will stand up and we will ask you to sentence Travion Smith to life in prison because he does not fall into that narrow category of individuals for whom the death penalty is reserved. Thank you.
Thank you, Ms. Day. Move that podium. All right, evidence for the state.